the first case to come before the court today, State of Ohio v. Donnell, Lawson. Attorney Kelly is here for the appellant. You will have 15 minutes to present your argument. Please stay behind the podium, keep your voice up. As you know, these are being recorded. You shouldn't use the names of any children or minors or victims should that be relevant. And the judges have read your briefs and we are ready to proceed when you are.
Okay. May it please the court, Attorney Angie Kelly on behalf of the appellant Donnell Lawson. The first question for the court's consideration today as part of this is whether or not the trial court erred when it denied defendant appellant's motion to suppress the statement that he gave to police. As the court is, I'm sure, very aware, this is a de novo review for the court with a suppression hearing, and the question of whether or not a statement given as a waiver of Miranda should be suppressed is twofold: of whether or not it is voluntary and whether or not it was knowingly, intelligently, and voluntarily waived at that specific time. In this instance, our position is that the defendant's statements were not voluntary because they were not the product of free and deliberate choice. Not arguing that there was any coercion, it's more of a deprivation type of a situation. And the focus of that, from our perspective, would be the amount of time that passed that he was there, as well as the amount of time that he had been without any type of sleep in order to be able to maintain his composure. Factually, it appears as though the defendant was up until 4 or 4:30 in the morning. There is no indication but the amount of sleep based on the time of the incident would indicate that it was not very long. He had been up all night partying and doing drugs and not sleeping, and was taken straight to the police station where he was then inquired of by detectives for a lengthy period of time.
Was there any evidence the officers were aware he was up all that time, or had any idea if he had slept some during the night?
I believe there was some indication in the record that they were aware of that between both mother and them, because they said that the incident had taken place roughly, I think it was supposed to be around like 6 o'clock in the morning. Officers came on scene, and he was on scene at the time of the arrest and taken directly to the station, and these were first shift detectives that came in at, I believe, 7 a.m. And started interrogating him somewhere around 7:30. So they should have been aware of the fact that he had been without sleep, and they were definitely aware of the fact in their conversations with his mother, who they were also interrogating, that he had some mental health diagnoses, that he was not being treated for those diagnoses, and that they had been up using illicit substances and alcohol most of the evening. So that, I feel, applies more to the second prong of the analysis. In all of those is that it wasn't knowing, intelligent, and voluntary because he was not in a position where he could comprehend the severity of the waiver of those rights. And one of the things that has gone through, at least in my head, as we review that, I know that there's certainly a law out there that says that intoxication is not defense and things of that nature, but I mean, when somebody walks into a courtroom and decides that they're going to enter a plea of guilty and they're waiving a litany of constitutional rights, they are always asked, are you under the influence of any drugs or alcohol that would impair your ability to understand what you're doing here today? This right is no less vital than any of those rights are, but that is not something that took place in this case, and it's not something that I see in normal practice by police. It is not abnormal for somebody who is intoxicated to be waiving their Miranda rights, for somebody to be sitting in an interrogation room for 6.5 hours after being up all night, that the officers don't inquire as to whether or not that individual even has the ability to read or write the language. The only factor that really plays in the favor of the police in this particular case is that he had previous arrests under his record. So you could argue that his experience as a criminal defendant would indicate that he knew what he was doing. But given his behavior and all of those other factors, it's our position that a reasonably prudent police officer would have inquired more.
Counsel,
Yes.
when you say his behavior, can you explain what you mean by that?
Well, there is an extremely lengthy videotape that is part of the record in this case, as I'm sure that you're aware of at this point in time, but I mean, he was talking to himself, he was rapping, he was pacing around the room. He told police officers that the devil made him do it. He said there were demons in the room that he was talking to. It was really, and even the detective's testimony at a couple points during the suppression hearing were that it was extremely abnormal behavior.
And was that from the very start of him going into interrogation?
It appeared to me that it decompensated as it went along. I suppose that's something that the court can view and make their own determination on. But he was pretty unaware, and there is some indication in the record, and I know that his mother relayed a lot of it in her testimony during the suppression hearing, that there had been an incident just days before where he had a psychotic episode and jumped out of a window, and they had to call the police. So his mental stability was made known to the police, and it is our position that they should have inquired, at a minimum, should have inquired further as to what effect, if any, his mental health, his sleep deprivation, and his substance abuse would have on his ability to understand that he was waiving such an important constitutional right.
When they read him his Miranda rights, it's my understanding it was from the briefs that it was before the first interview.
Correct.
Okay. And there's some indication from the state's brief that you asked him if he understood.
He did.
Okay. So he's in there the first time, and they give him Miranda rights, and did they ask him each time after they, throughout the Miranda, or did at the end ask him if he understood, or?
I want to misspeak. I believe it was at the end.
Okay, and
It is on the video.
Yeah.
It is only oral, there's no written waiver in this case.
okay, so they didn't then have him sign?
No, it was a completely oral waiver that was taking place, but it is on the video. I believe it was at the end. It was not individualized, but I could be wrong with that. Certainly don't want to mislead the court.
There's nothing in your recollection on the video that would indicate his inability to understand those rights as they were being read to him? I mean, he answered, yes, I understand.
He said yes. I certainly can't get around that, but when combined with the oddness of the rest of his behavior throughout, to my way of thinking, it required additional review by the police, because it draws it into question. It is not abnormal for anybody, but less educated people who are addicts, people who have mental health illness, to just agree, not agree, yes, I understand, methodical, which would be more of what I feel would have taken place in this instance. It certainly should have, I think it should have set off alarm bells, in that they should have to inquire a little bit further. The idea that somebody who has that, there's no reason he couldn't have slept it off or taken a break and they could have interrogated him afterwards. I understand that police like to try to get to the crux of the situation as soon as they possibly can, especially in a circumstance like we have here, because of the urgency of it. But I also feel like if somebody's going to be asked to do something like that and to waive something that's so imperative to them, that there should be a little bit more of a duty or obligation upon law enforcement and or the court system to at least attempt to ensure that that person really understands what they're nodding yes to or saying yes to. And that clearly did not happen in this case.
So counsel, then you're saying that the obligation was at the beginning, before the interrogation began. It wasn't after that?
Honestly, I feel like it's an ongoing obligation. I don't know, there's no law to support that. So, but just my personal position as an attorney, that if these red flags start going up, that one would continue to inquire. But yes, definitely at the beginning, and the reading and writing thing plays a role with me. I realize this was an oral confession, but we are also dealing with a lot of people who have varying levels of educational background and comprehension. And to have no inquiry as to whether or not it's something that he could even comprehend when he was saying yes to me, violates any idea of fundamental fairness, especially when we're dealing with something as serious of this nature. So we feel that under the circumstances that the trial court was mistaken and made an error of law, and that this interrogation should have been suppressed in its entirety because it was not knowingly, intelligently, and voluntarily made. doesn't have any other questions on that as it relates to the second proposition of law, I would be looking to rest on my brief.
Any questions? Okay, hearing none, we thank you very much for your presentation. The court will take it under advisement, issue a decision in due course. The court of courts will mail a copy of the decision to you on the day that